Moving on, for the first of the case, in February 2012, Muhammad Khairuldi bin Abu Halim bought a Toyota Camry from Sun Yip Used Car Trading, which is the dealer, for RM150,000 ringgit 664.70. To facilitate the purchase, the appellant sought financing from the respondent, which is in this case RMB Bank Berhad, in the amount of 134,000 ringgit. So, on February 14, 2012, both parties agreed to an Islamic hire purchase agreement based on Sharia principle of Al-Ijarah Tumma Al-Bay, which is ITAB. The respondent, which is the owner, leased the vehicle to the appellant as a hirer for a total hire purchase price of 190,000 ringgit 408, and this was to be repaid with an 30,000 ringgit down payment and also 107 monthly installments. So, the dispute in this case involves several events regarding the car's legal status. Firstly, the vehicle, who is later bought by Mr. Khairuldi, was once seized by the Royal Malaysian Customs Department (KDRM) on October 18, 2012. In October 2015, the Customs Department initiated an action against both the appellant and the respondent under Custom Act 1967 because the vehicle's custom taxes has not been paid yet and the custom number 1 form was found to be forged. So, the appellant was later charged with an offence under Section 135 Clause 1 Clause A of the Custom Act. While he was initially acquitted by the Sessions Court in 2019, the High Court later allowed the prosecution's appeal and ordered the appellant to enter his defence. However, due to the seizure, the appellant ceased making installment payments. The respondent issued a notice under Section 16 of the Hire Purchase Act 1967 and subsequently a solicitor's letter in July 2013 demanding the outstanding balance of 174,055 ringgit 30 cents. An initial legal action, which is the first action, resulted in a consent judgment on February 18, 2019, where the appellant agreed to return the vehicle to the respondent. However, the appellant failed to comply with these terms as the criminal case was reopened. Consequently, on July 8, 2019, the respondent refiled the claim for the outstanding amount plus late payment charges. The respondent thus applied for summary judgment under Order 14 of the Rules of the Court 2012, and the appellant contested this, arguing that the agreement was void ab initio because the respondent failed to provide quiet possession and that the subject matter, which is the car, was an unlawful object due to unpaid taxes and forged documents.
There are three issues arise from this case. The first one, whether the respondent failed to provide the safe possession of the vehicle to the appellant. The second one is whether the subject matter of the hire purchase agreement is unlawful object, and the consideration for the hire purchase agreement is also an unlawful consideration. And the third issue is whether the custom form number 1, which was confirmed, was received by the respondent before releasing the 124,000 ringgit Malaysia.
Moving on to the contention by both parties, which is the first one, the appellant. In this case, the appellant has presented several arguments in their contention against the respondent. Basically, the appellant argued that they are not liable for the financing repayment. This was based on the failure of the respondent's duty to ensure the grant of quiet possession of the vehicle. This was causing them to raise their claims against the respondent for breach of statutory warranty as stated under the Hire Purchase Act 1967. Their right to quiet possession was violated as the Royal Malaysian Customs Department seized the vehicle due to unpaid taxes. Other than that, the appellant also argued that the respondent had failed or been negligent in their duty to make sure the vehicle did not have any liabilities from the third party before the delivery to the appellant. They stated that the letter of undertaking was breached as the respondent failed to fulfill the conditions provided by the appellant. The respondent had released RM124,000 in financing to the dealer without proper verification when it should have been released only upon receipt of a certified custom form. This is supported by evidence from the criminal trial which indicated that the forms were forged and did not appear in custom records. Subsequently, the appellant submitted that the hire purchase agreement between them was void ab initio, as the subject matter was considered an unlawful object. The forged custom form had caused the vehicle to enter the country illegally and contravened Section 24 and 25 of the Contracts Act 1950. The appellant also referred to the case of S. Mankam and others against Ismail bin Muhammad and others to support his arguments. Furthermore, the appellant contended that the agreement even contradicted the Sharia principle of Ijarah, as the subject must be legally valid and free from uncertainty. Due to the vehicle having liabilities and being illegal, the agreement failed to meet the Sharia conditions. Therefore, the appellant concluded that his failure to repay the loan was caused directly by the vehicle seizure on the ground that the respondent had failed to ensure it was legal. Lastly, the appellant stated that if the agreement is declared void by the court, then the respondent should claim damages against the third party for their undertaking rather than pursuing the appellant for the loan.
There are several arguments raised by the respondent in order to counter the arguments made by the appellant. So firstly, respondent claimed that they did not have the obligation to ensure good title or quiet possession. The reasoning behind this is because it was not the function's responsibility to ensure such thing for the appellant. Subsequently, they believe that they did not breach any duty under hire purchase agreement. So, they had strengthened their argument with the principle applied in the case of Honor Bank against Jaya Prakash Pillai, where the financier did not fail their performance if a vehicle is seized by the Customs Department due to unpaid taxes. As the respondent argued that the vehicle was seized due to the failure by the appellants to pay the taxes despite being given the opportunity by Customs Department to pay the taxes to recover the vehicle. The respondent relied on the same case, which is Honor Bank, where to support the argument in which it was not their responsibility to settle the unpaid taxes. In addition, the respondent had also relied on the case of Malayan Banking against Nur Azhar, from which the case it can be inferred that the financier does not have the duty for any imperfections on the vehicle, as the financier is not the actual owner of the vehicle under hire purchase agreement. Lastly, the respondent has denied their liability on the issue of falsified customs form, and instead the third party in the case should be liable. They has referred to Section 36 of Hire Purchase Act as the basis where it has been stated within this provision that the dealer or agent on behalf of the owner are the wrongdoer for the false representations which led to the formation of the agreement.
Moving on to the judgment of the court, whereby the court dismissed the appeal and demanded the appellant to pay the cost of 5,000 ringgit. On to the ratio decided of the case. The first is that the court in this case considered the duty of the respondent, which is the CIMB Islamic Bank as a hirer, has the obligation to pay the tax set by the custom. The appellant argued that when the respondent failed to do so, he did not have the safe possession of the vehicle. The court accepted the respondent's argument by referring to the case of Malayan binti Berhad and Nur Aziah binti Abu Hana Supra. The court in this case stated that by the reason that a hirer is not the owner of a vehicle, under a hire purchase agreement, the hirer does not have the duty to ensure that the vehicle in agreement is in good condition when it is to be rented by the purchaser. Furthermore, in the context of settling the tax payment set out by the custom, it is the duty of the purchaser to do so and not the hirer in the hire purchase agreement. Furthermore, the court referred to the case of Hong Yong Beng Berhad and Jaya Prakash Pillai, anak lelaki Jaya Goltan, where the supercar in this case was seized by the custom due to the defendant not paying the installment fee to the bank, and the defendant argued that hire purchase agreement was void. The court in this case held that the bank is not guilty when it comes to the seizure of the vehicle by the custom. The court further held that the defendant were given an opportunity to settle the tax but refused to do so, and the court came to the conclusion that the bank does not have the duty to pay or settle the customs duty or any other tax payment because it would be inconsistent with the commercial realities and obligations. By applying to this case, the court rejected the appellant's argument that the car cannot be used in good possession and good title due to the car being seized by the custom. Although the appellant stated that he had a belief that as a purchaser, the car would be free from any debt or taxes made by a third party. Therefore, the court concluded that the appellant has the duty to ensure that the vehicle of the agreement is free from any financial issues, specifically any taxes or duties made by the custom, so that he may enjoy the good title and good possession of the car. Lastly, the issue of whether the custom form number 1, which was confirmed, was received by the respondent before releasing the 134,000 ringgit is not relevant because it is not the respondent's responsibility to determine whether custom tax has been paid to proceed with the hire purchase transaction.
The court has established that in Ijarah transaction, the bank plays its role as a financier rather than the true owner. When the bank holds legal title for a financing arrangement, it does not possess the vehicle physically, nor does it have the expertise to determine the specific condition and the legal status of that vehicle. This was articulated in the case of Public Finance Berhad and Ehwan bin Saring, which Muhammad Ghazali Judge stipulated that the financing companies are merely act as money lenders and not the owner of the vehicle. Therefore, they cannot be held responsible for the condition or quality of the vehicles that they finance, as they do not physically inspect them. In addition, it is legally unreasonable to impose a duty to the bank to inspect the condition of the vehicle or to determine the originality of the vehicle documents. Moreover, a common contention in such cases is considered as a breach of implied warranty of quiet possession. However, the legal interpretation already clarifies that this warranty is intended to protect the hirer from the interference by the owner, which in this case is the bank itself. This is not an absolute guarantee against all the external disruptions. Consequently, when the vehicle is seized by a third party, such as the customs department, due to the unpaid taxes, this act constitutes an intervention from the third party, since the seizure does not result from the bank's conduct, which is still failure to settle taxes, is that it does not constitute a breach of the quiet possession warranty by the bank, and in other words, the bank has not interfered with the hirer's usage at all, but the interference stems from a pre-existing defect in the vehicle's documentation caused by the dealer of the vehicle. In conclusion, the seizure of a vehicle by the customs department does not absolve the hire of their financial obligations towards the bank. The courts prioritize the commercial real titles that the banks act as the lenders, not the body that inspect the specific condition of the vehicle. Furthermore, the proper legal solution or recourse is not to withhold the payment to the bank, instead to initiate the legal proceedings against the used car dealer for fraud, misrepresentation, and the breach of the contract regarding the unpaid taxes. When the bank has already fulfilled its obligation and role as a financier, it is entitled to recover the debt, while the liability for the vehicle's burden lies upon the vendor who sold the vehicle.